question here, Jana, that's dropped in during your segment. It is open to everybody, but it's just asking, or rather just saying, you recommended having both an internal privacy policy as well as an external one. Just a little point of clarification just about why that may be important and what the fundamental difference is between that which is internal and that which is external. So just a quick note as to why you feel that may be important and what the primary differences between an internal and an external one would be.
So the difference is the audience. So the audience for the external policy is the world. And anybody, I mean, presumably you're on the internet advertising your business, your product, whatever. And so that's what you're putting out there to the world as your representation, almost a guarantee of this is what we do with your data. And you're making a representation that that is the accurate statement of what you do with their data. Your internal policy, the audience for that is the folks who work for your company. And so you may want to make additional commitments in terms of your internal group, that are loftier or broader reaching than what you want to commit to on your external facing. So it's really about what are you want to put on your website what you're comfortable being held to and what's actually required. But you may, for administrative purposes, internally actually go beyond that. And want to improve or whatever, and that's great, and you should do that, and wonderful. But there's no reason to set yourself up for a liability problem by putting something out there that's more aspirational than actually reality.
Thank you so much for that, MJ. A quick question here for yourself. Just asking, does the CPRA require a company to develop or even employ an opt-out preference signal on its website?
No, that is going to be optional. The opt-out signal is one way that a company can allow individuals to exercise their right to opt out of sale or sharing, and all of that is going to be subject to rulemaking. So we'll want to see what the rules say before we give advice on opt-out preference signals. Thank you.
Thank you. Thank you so much, Jana. We did get a quick question for yourself, just asking, pretty sure that the CCPA doesn't apply to the company I work for because we're too small and don't meet any of the necessary thresholds. But the CCPA definitely applies to the parent company as we share common branding with our parent company. Now, would that mean that the CCPA were to apply to that subsidiary, or would it just apply to the parent company?
Yes. If you are either owned or own a company or control a company that is subject to the CCPA and you share common branding with them, then yes, the CCPA applies to your company too. The CPRA actually clarifies that to some extent and makes it more clear that it's not just the control or ownership, but also you have to share, the two companies have to share the personal information. And also common branding doesn't just mean that you share the same trademark or service mark, but also that the average consumer would understand that you're in common. So there's some clarification to that under the CPRA, but the way that you've said the question, yes, you would be subject to the CPA as well.
We'll come to yourself for this final question here. Just asking, is the CPPA's enforcement authority, is that retroactive?
So the answer is no. It's only going to apply to violations that occur after July 1st, 2023. So prior to that, it's going to just be the Attorney General and anything that comes up in civil litigation.